start when I'm...
Go.
Hi, my name's Nick Goldstein. I'm the Assistant General Counsel and Director of Regulatory Affairs here at the American Road and Transportation Builders Association. As some folks may or hopefully know, ARTBA is going to be proceeding in its lawsuit against the U.S. Environmental Protection Agency by making its argument in federal court on November 9th. The lawsuit has to do with just how much authority EPA has under the Clean Air Act to let states develop individual regulations which could affect construction equipment and the transportation industry in general. With me is Larry Joseph, who's going to be arguing the case on behalf of ARTBA on November the 9th. And what we hope to do in the next 20 minutes or so is just go over a series of questions about the case so that hopefully it becomes understandable to everybody in ARTBA's membership. So I'll be conducting a short interview with Larry here and just asking him the basic points of the case, and hopefully it'll give everybody a better understanding. Larry, I guess the first place we should start is describe the history of the case. I mean, it goes back quite a few years, doesn't it?
Yes, it does. First of all, there's a statute that was amended in 1990, then some regulations in the mid-90s, and then ARTBA did some litigation in Texas in right around 2000, 2001. First of all, the statute, in 1990, Congress preempted the states from regulating construction equipment in certain ways. This mirrored the preemption that already existed for on-road vehicles, so that basically the federal government sets standards, and California is allowed, and only California, is allowed to adopt state standards that are different, more stringent usually, than the federal standards, but they have to get EPA's permission on a standard-by-standard basis. And then other states can opt in. They can say, we want to do the California car, not the EPA, the federal car. And so what Congress did in 1990 is they essentially adopted that model for construction equipment for the first time, for non-road equipment. That's locomotives, construction equipment, leaf blowers, ships, so anything that's not a plane or a on-road vehicle. And there were a couple of differences, though. One is that the preemption for non-road equipment, which includes construction equipment, preempts not only state standards for new vehicles, but also for existing, or for used vehicles, things that are in use. Also, with respect to locomotives, because there's a long history of locomotive preemption going back into the last, well, now it's two centuries ago, the 1800s. And so Congress addressed that in this new preemption for non-road equipment. They addressed the fact that locomotives were already preempted in a special provision. And what's good for the construction industry, and we'll talk about this to some extent as we move on, they grouped construction equipment under 175 horsepower with locomotives, same for farm equipment. So it's essentially a political deal, probably, in the conference committee for the Clean Air Act amendments of 1990. They grouped or hitched small construction equipment and small farm equipment with locomotives. So that's the Clean Air Act preemption from 1990. EPA is supposed to issue rules. They did in 94. And what they did, and this is the first sort of tricky part on their part, is they said, you know what, locomotives are hard. Let's leave them aside and let's do the preemption rules for everyone but locomotives. And the rule they came up with was very stingy as far as the preemption. It basically says, once an piece of equipment rolls off the showroom floor, it's no longer new. So any preemption that attached to new vehicles disappears the instant.
And that's even if it hasn't been used in a project or anything. It hasn't done
Once
any
it rolls off, yeah, the first foot.
Okay.
Yeah, right. It's really. I mean, they were not very friendly to our industry. Congress was friendly to our industry, but EPA didn't implement that in a sensible manner, I would argue.
So when did ARTBA first get involved with this?
Well, ARTBA did not get involved in the litigation in the mid-90s that basically the D.C. Circuit, where all these rules are challenged, they upheld this stingy EPA interpretation, and then EPA in a couple of years came back and issued a very generous locomotive rule. So you have this sort of separate treatment for locomotives under the same section of the same statute. So Even still, ARPA wasn't all that injured by this until late 99, early 2000. Texas adopted regulations that did two things. They said you cannot use equipment in the morning from 6 until noon, 6 in the morning until noon. And the reason was they thought if the emissions from construction equipment went up into the air in the afternoon, they'd be floating around mostly at night, and they'd dissipate, and they wouldn't turn into smog. That's the theory behind it.
Because they were tired from having a heavy lunch or something.
Yeah. No, it's just the idea is to shift the emissions so that they're later in the day and they wouldn't be in the air to cause smog. That was one thing that was just horrible. And then the other thing was they wanted to accelerate the turnover of equipment so that you would have to retire equipment before it needed to be retired, certainly, way before that, and buy newer equipment that in theory would emit less. So those were the two things that Texas tried to do, and ARPA got involved at that point. And one of the arguments we made that really wasn't before the D.C. Circuit in the mid-'90s, because trains had been left to the side, is we said, Your Honor, how in the world can you justify this no preemption interpretation of the Clean Air Act when that would mean that any state in the union can regulate trains? Because trains are, have this strong preemption. They've had it for decades. And so how could Congress just, without even mentioning the issue, wipe that away? You have to treat us like you treat trains. And the judge accepted that view. ARPA prevailed. Texas rescinded its rule and then adopted a mechanism, Senate Bill 5, if you're familiar with it, where the state would fund the retrofits that they needed to get the clean air. So instead of mandating cleaner fleets, the state actually helped the industry purchase cleaner fleets.
Now, what did ARPA do in terms after that case with the EPA?
Right. We didn't want to get fooled again, so to speak, and so what we did is we said, Dear EPA, we petitioned them to change their rule. That's the sort of short answer, and we explained, that by leaving the locomotives to the side for a moment, they missed perhaps the strength of the preemption that's really intended in this statute, and shouldn't they therefore amend their regulation? So we petitioned them to amend it, and then, unless and until we ever were bothered again, we didn't have to have an answer. But when California started to adopt retrofit rules, when other states, in response to their Clean Air Act state implementation plan submittal requirements, started to look at non-road equipment, then we turned back to EPA and said, and we've been writing them occasionally, like every 6 months, and say, do you have an answer yet? But we were in no urgency because no one was pushing on us. Once that started happening, we then tried to accelerate EPA into answering our petition.
And when, if ever, did they answer our petition?
Well, they answered it, but they didn't answer it. They drug their feet as long as they could. We sued them to force them to answer us. And then they said, okay, we'll do a rulemaking. So they did a rulemaking, and they proposed to do nothing, and then they did nothing. But the advantage for us is now they've taken final action of doing nothing. And so we're back in the same place we were or would have been in the mid-'90s if we would have litigated it then. But now we have we didn't really have a harm then. No one was pushing to regulate us with retrofit rules or things like that. They are now. And so we have a case against EPA's interpretation. EPA's sticking by their interpretation. And we are before the D.C. Circuit. It's briefed, and as you said, the argument's in early November.
So just to put this in perspective, we gave EPA about 6 years, roughly, I think from 2000 it was, to answer before we seriously considered litigation. I mean, the litigation is a last resort for us in terms of speaking, isn't it?
Right. I think that's fair. The petition was actually April of 2002. It's now 2009, so that's, what, 7 years?
Okay.
And, we did the proactive thing. We tried to get them to change the rule nicely, and now we're in court because they drug their feet the whole time.
And what is ARTBA asking the court to do in this litigation? What are we asking them to tell the EPA to do? There's
4 parts to it, really. There's the notion that some states try to say, I'm not regulating your equipment. I'm just saying your whole fleet has to have fleet-wide emissions of a certain amount. That's not regulating any one piece of equipment. That's a specious argument. And so one thing we're saying is, look, a rule that applies to fleet-wide is a standard just as much as an emission standard for a single piece of equipment. That's one thing we're asking. Another, this came up out in California with the Los Angeles area, South Coast Air District. They're basically arguing that there's a market participant exception to preemption. And that basically is that if I, the regulator, want to go out and buy a car that runs on solar power, that's my business. And the fact that I can't tell anyone else to buy a solar-powered car, that doesn't have any effect if I want to choose to, on my own, go out and buy a car. That's called the market participant exception. So if California wants to mandate that California agencies use these clean fuel vehicles, that's presumably okay. Where it gets tricky, and this is particularly true for your members, is what if they try and hitch it into a contract? So it's not...
So they say you could only have this job if you get this piece of equipment?
Correct, right. And those kind of contracts, have their place. What we're talking about here is what is preempted and what's not. When I do a contract, I can't say, and if you don't pay me, you go to jail. That's called a liquidated damages clause that's a little overbearing. And so what they're doing in these contracts is they're basically saying, you have to have this equipment, and if you don't, it's a violation of the Clean Air Act. That's a felony. And so it's a liquidated, so basically what we're saying is the market participant exception to preemption simply does not apply when the state is enforcing its contract with criminal penalties or punitive civil penalties. So that's the second thing, that you can't, maybe you can have a clean equipment contract, but the or else can be something that you mitigate in the way you would mitigate any contract term. It's not go to jail. The other thing, and we talked about this earlier, is you have to treat us, construction equipment under 175 horsepower, which I think is about a third of the fleet for most people in the on-road construction industry. You have to treat us exactly like you treat locomotives, and that is a huge advantage because the locomotives have very generous preemption, as I said. And then the last thing is this in-use control, the notion that you can say, don't use the equipment. I'm not setting a standard, I'm just telling you not to use it. That's essentially the same thing, and it's preempted by this Clean Air Act language that basically says states are preempted from adopting any standards or other requirements related to control of emissions. So that's a very broad preemption. It includes telling people they can't use equipment as well as telling them how clean it has to be.
So what I'd like to do now is sort of take this to the ground level. Why is it important for the transportation construction industry to have these sorts of limits set on what can and can't be done under the Clean Air Act vis-a-vis preemption? And I guess when you're answering this question, I know there's a California rule that we've mentioned briefly a couple of times. Perhaps you could get into that, because I know that illustrates, I think, the importance of this case to the industry as a whole.
Well, yes. I mean, if you've been following the California rule, it imposes billions of dollars on the industry. ARB says, the California Air Board says $3 billion or $4. Industry experts say $13 billion over 10 years. I mean, so it's very expensive. It basically takes all your equipment and makes it obsolete. You have to retrofit it or buy new equipment. So it's an incredible cost burden, and that actually, it's worse than that because it feeds on itself. The collateral you would have used to buy new equipment that they're forcing you to buy, which is your existing equipment, is devalued because you can't use it anymore. And indeed, if you're in a state that has bonding requirements for work, that same collateral that you would use to bond your work is devalued. So you can do less work, or you can bond less work. So how are you going to make the money to pay for all this? So it's a genuinely crazy, burdensome rule. If we win this case, let me back up. We're challenging the rules for how EPA grants these waivers of preemption to California. We're not challenging the specific California ORD rule, which is a waiver proceeding that's before EPA. They're thinking about it.
Yeah, what we're essentially saying then is, hey, EPA, we understand that you can allow California to do certain things, but there are limits as to just how much you can allow them to decide.
Absolutely.
Is that a fair way?
And And I mean, the good thing is we can lose this case and still beat the ORD waiver proceeding. We can still beat the California rule if we lose this case or if the court decides not to address some of the issues. If we win this case, though, it's a gimme. The ORD rule violates our view of how EPA is supposed to do this. And if we win this case, then the ORD rule is back to square zero out in California. So the question was, why is it important to do this, and how? So that's how it hurts you. It hurts you in your pocketbook. It hurts you with the value of your equipment. Why it's important? I mean, one, we might stop the ORD rule. Two, if we don't do this kind of thing here, we might certainly be fighting California in a few months downstream on the ORD rule if this litigation weren't going on. But there's also contract requirements in this state. There's fuel requirements in another state. So this is a chance to avoid piecemeal litigation by addressing. I mean, essentially, rather than arm wrestling an octopus, we're going after the head. And so, if we win this, we change the way things happen in any state that's guiding its behavior by how it deals with EPA. Because if we beat EPA, then EPA has to live with the ruling, and then that affects the other states that interact with EPA.
Well, and actually, that's where I wanted to go with my next question. ARTBA has members in just about every state in the country. We have members in Texas and Pennsylvania and New York, as well as California. So I guess this question sort of directed to our non-California members in a sense. Explain why this case is important to somebody that's not going to be affected immediately by the California rule because they're a contractor in Pennsylvania or Florida.
Well, those are two states, by the way, that are purportedly thinking about adopting the ORD rule if it gets a waiver. So if we stop the waiver, then they can't adopt it. So that's one sort of one step removed kind of indirection. But even if you're in a state that would never, let's say Florida or Pennsylvania, would never adopt this ORD rule in its entirety, there's other ways that this affects what happens in those states or any other state. First, if those states want to sort of backdoor some California requirements, so not adopt the whole California regime, but merely say in contracts, for example, you can use any piece of EPA or California equipment that meets this standard. Well, if the EPA equipment doesn't meet that standard, that's effectively the same thing as mandating California equipment. But if we beat California, then they can't do that. But even if it's a state that doesn't want to bring California in at all, there's several ways this helps. First of all, if the state adopts a construction equipment control for purposes of limiting particulate matter or oxides of nitrogen emissions, they will not be able to go to EPA and get approval into their state implementation plan for those reductions if they're mandating reductions that we and EPA now agree are preempted. So
that's a primary motivating factor, right, when they adopt the controls. I mean, going back to that Texas case, that regulation on only using your construction equipment in the morning, that was done so they could get EPA credit for it.
Absolutely. And they were, if they wouldn't have done that to get the credit, the environmentalists would have sued them for not meeting the Clean Air Act mandates for reducing pollution. And so the environmentalists might have tried to force it in court. They tried that in Georgia, for example. So by taking away EPA credit, you take away one of the primary motivations for someone to want to do this kind of rule. And conversely, you increase the state's willingness to work with us, like Texas did, to come up with a way where we can agree on a form of reduction that they can get credit for. And this is maybe a small thing until you're in trouble, but if you ever were in trouble and this were a Clean Air Act requirement, then you can't get a variance. There's citizen suit provisions. It's a felony. If you're operating just under state law with something you work out with your state, none of that Clean Air Act overlay comes in. So there's lots of reasons to want to keep this outside of the Clean Air Act. And by beating EPA, we accomplished that.
Finish.
Okay. The fortunate or unfortunate thing is it won't solve the entire problem. If Pennsylvania, for example, or Florida, if they chose to regulate construction equipment without seeking EPA credit, just to regulate it because they thought it was a good idea. At that point, you would have to go to Florida or Pennsylvania and sue them there in U.S. District Court, like we did with Texas. And so the D.C. Circuit opinion that we'll get won't be binding there, and the EPA regulation won't be binding there. Indeed, in the Texas case, we were able to win, notwithstanding a contrary D.C. Circuit opinion and a contrary EPA rule. So it's possible. So you still have to go out and win, but it's much easier if you've got a decision on your side from the D.C. Circuit, and more importantly, perhaps, if you have the EPA regulation changed as a result of our litigation, it's going to be much easier to win in Georgia or Florida or Pennsylvania, wherever, if the regulations are on our side.
Now, I guess the last area that I want to cover is, in terms of on-the-ground effects that we can, that contractors across the country, ARPA members across the country can expect to see in terms of their equipment. If we prevail in this litigation, what's at stake for them in terms of the individual pieces of equipment that they use, in terms of the fleet, in terms of the sort of things that they'll have to deal with every day in the jobs that they do? Sure.
I alluded to this earlier. I mean, if we don't prevail, then you're looking at existing equipment that gets devalued, so you can't use it as collateral to buy the new equipment you're being told to buy. If you have a bonding requirement, you can't use it as collateral for your bonding requirements. You can do less work. I mean, it really feeds on itself. So the downside is very down. If we do win, we're looking at maintaining flexibility on how you use your fleet, keeping the useful life in the equipment that you bought. I mean, this is equipment you bought, and it was when you bought it, they said this is the emission criteria that it has to meet, and it does meet it. And this is really the first wave of regulations where they're basically going in and retroactively saying, hey, that model year X vehicle that you bought, you know what, the emission standard was too high. We're going to wind it back. I mean, that's something you do with the manufacturer. That's something you do forward-looking, whether it's California or EPA. That's how you set regulations, and then it rolls over into the fleet over time. And if you want to use incentives to have early rollover, that's fine. But so it's being able to use your equipment. It's primarily all money. This is all about money. And fairness, actually. I mean, you bought the equipment. It was legal when you bought it. You should be able to use it. Retroactively changing moving the goalposts just simply isn't fair.
Now, I guess the last question I want to ask is, the case is going to be argued on November 9th. Is there any timeline that you could throw out there as far as when we may have a decision? I realize it's nothing definite, but...
Yeah, I mean, the 2 to 3 months is on average, so I would think by the end of January we should... we'll certainly have a sense on November 9th how it went, and then presumably by mid-February would be 3 months. That's 90+% chance it'll be done by then.
Great. Well, thanks, Larry, for taking the time to help to explain this case. For those of you that took the time to watch this, I hope that it actually explained what ARTBA is trying to do in its litigation with EPA. And we'll be posting all of the details on the case and keeping you updated through www.artba.org. And if you have any questions, you can also find my information through the ARTBA website, and we'll also have Larry Joseph's information up there as well. And if you have any questions you'd like to ask him directly, I'm sure he'd be fine with that.
Absolutely.
Thanks for taking the time to listen.